We are back in session. I'm guessing Ms. Uche wants to be here. Thank you, everyone. Mr. Webb, I will hear from the Office of Special Prosecutor, arguments and aggravation.
Thank you, Your Honor. As Your Honor knows, this is the sentencing phase of the case where we, from the Special Prosecutor's Office, get a chance to kind of sit back and reflect with the court for a bit and talk about whether there are aggravating special circumstances in this case that we want to call to Your Honor's attention, so you can consider or focus on them if you choose to in rendering sentence in this case. There are three. There's three I want to talk about. Number one, I do want to talk about the underlying serious criminal misconduct that Mr. Smollett engaged in and that he was convicted of by a jury after they heard all the evidence, and they, the jury, made the decision that he was guilty of 5 felony offenses. I want to talk about that. We've heard a lot about that in this sentencing hearing, a lot of talk about how it's kind of a low-level thing, not a big deal. I want to talk about it. Number two, another aggravating circumstance that I think is a big issue is that during this trial, Mr. Smollett made the choice, sitting here in front of a jury, listening to evidence, he decided to beat the case and go in front of a jury and take an oath to tell the truth and decide to lie to them, and lie to them for several hours. It was an effort to obstruct justice in this courtroom, to try to convince a jury to ignore evidence and accept his lies, and they didn't do it. They rejected it all, and after, 2 or 3 hours of deliberation, found him guilty of 5 counts. So I want to talk about that. The third is the issue of contrition. As far as I know, as I stand before Your Honor, in the 3 years that this case has been pending, 3 years, Mr. Smollett has never made any statement, publicly or in a courtroom or in a court pleading, to ever accept any acknowledgement that he's responsible for what happened here, to admit that he in fact engaged in wrongdoing, to apologize for making mistakes. None of that has happened. Not a single act of contrition has happened so far in this case, and I at least want to talk about that as a third factor. Let me go through them one at a time. On the first one, on the seriousness of misconduct, I know we've heard a lot about this and it's a low-level offense, but I want to talk about it in a minute, because what I believe, if you look at the evidence that was introduced during the trial, what you see is that Mr. Smollett actually engaged in a very well thought out plan, a calculated plan for him to fake a hate crime to benefit himself because he's black and gay. He made the choice. He didn't want to fake an automobile accident. He made a choice. He wanted to fake a hate crime to benefit himself because he's black and gay. And he then made a choice. He made the choice to falsely report it to the Chicago Police Department because he wanted public attention to it. The only reason, the brothers had nothing to do with that decision. That was Mr. Smollett's decision. He actually wanted public attention, called to the fact that he was reporting a hate crime. He wanted it to be made public, and that's why he reported it to the Chicago Police Department. He's the one that made that choice. Remember, he actually, when he planned out the fake attack, he wanted it to be put on a camera. There was a police camera overhead near his apartment building. He wanted that filmed. In fact, that's why he told the brothers where to do the attack, because he's the one that wanted a great deal of public attention, called to this because he thought he would benefit from it. And then he made the decision. It wasn't like he sat down with a policeman for 10 minutes you've heard 5 different police officers testify in detail. He spent hours talking to police officers, going through details that were all false. To convince them that there really was a real hate crime, and he lied to them over and over and over again. And the idea that lying to law enforcement, taking their attention away from other crimes and criminal activity in order to benefit himself is some type of low-level, insignificant activity. I respectfully reject that as not being consistent with the evidence. And respectfully, to what I heard from others here today, there were consequences to others of what he did. And that's something the court is allowed to take into consideration. What Mr. Smollett did in this case is he denigrated, degraded true hate crimes, and he marginalized the people who are true victims of hate crimes. That is what he did. And he did that knowingly. He knew exactly what was going to happen. He didn't know he was going to get caught, but by what he did here, he's the one that made a choice that resulted in true hate crimes being denigrated, degraded, and true victims being marginalized. We know, in fact, it's in the Chicago Police Department report, that the hate crime victims of hate crimes are frequently minorities, whether it's based on race, religion, or sexual orientation. And studies show that that group of people are reluctant to report criminal activity to police, hate crimes to the police. And that was discussed in the Chicago Police Department report. There are studies that support that. It takes a tremendous amount of courage on behalf of someone who's been truly victimized of a hate crime to have the courage to come forward, to go through the process of reporting it, to go through our criminal justice system as a witness. It takes courage. And what Mr. Smollett did in this case clearly would have a marginalized, discouraging influence. It hurt the effort to have people come forward and report hate crimes. And that was wrong. That is serious misconduct and a serious consequence of what he did. And he did it in 2019. And if I want to go back to that time period, that's a time period where there was a lot of racial tension, divisiveness. Hate crimes were becoming far too common, and police were accused of not paying enough attention to it. And that society was trying to find a way, at least this is my view, of trying to find a way to make it clear that that needs to be reported. Hate crime needs to be addressed by law enforcement machinery in this country. And what he did, what Mr. Smollett did, to marginalize that, to discourage people from coming forward, I respectfully suggest is wrong. And that, and it was a normal consequence of what he did in order to benefit himself. Remember what the facts are. He made the choice in January of 2019 he felt that Empire was not paying enough attention to a hate letter about him that came to him, and he wasn't getting enough attention. And he decided to fake a hate crime to benefit himself. He wanted to benefit himself. That's why he did it. And he hatched the plan, and Your Honor, he did it all. Nobody else did any of this. I know you know the facts, but he did it all. He planned everything out at that time. He recruited the brothers. He went forward with this plan, and even to the point of trying to work out where they would actually do a dry run so that the brothers would know exactly where to do the attack at. All of that. He told them what to buy, what derogatory, homophobic, racial slurs to utter, to try to pretend as if there's whites involved by yelling out mega country. He owned every bit of the plan, and he worked hard on it. He planned it out, and he executed on it, and he owns that for doing that. And so, yes, it is serious misconduct on his part, and it had broad ramifications. And The true victims are, of course, number one, the true hate crime victims that are not going to report these crimes. They are the true victims. The police department, though, is a victim, and I'm going to talk about that, because sometimes the Chicago Police Department gets criticized for not doing things the way maybe people think it should be done. I'm not here to defend the Chicago Police Department, but I'm telling you, in this case, this Chicago Police Department shined. When this, and then we hear in this courtroom, the police department paid too much attention to it. They shouldn't have they shouldn't have spent so many hours investigating this misconduct, and they argued last night in a filing with Your Honor, they argued, well, we shouldn't have to pay restitution for all that because the police department spent too much time on it. My Lord, I wonder what would have happened if the Chicago Police Department took this hate crime, which on its face, by the way, is a heinous, serious, awful hate crime. Awful. Ropes, lynchings, gasoline. It clearly called out for a thorough investigation, and that's what happened. And we put 5 police officers on the stand. They testified in great detail to the 4 different occasions when Mr. Smollett lied to them. They described in detail 3,000 police hours, Your Honor, were devoted to this case instead of being devoted maybe to solving homicides or other cases. And therefore, Your Honor, I believe that the effort of the Chicago Police Department here, and when you look at the evidence, the fact that this police department within, I think, 15 days figured out what happened here. I mean, if you remember, what they were able to do in this case, I think was truly amazing, because what they did is that they were able to locate some surveillance tapes of these 2 suspects being dropped off around 1:15 in the morning in the Streeterville area. They traced it all through that area of where the suspects went. They traced that cab back to where the Ossadero brothers got into it in the, I think around Wells and North, and they solved the crime. They figured out what happened here. And that the point of that is that, and by the way, they did it, Your Honor, they did that as an incredible effort on their part, when we now know from the evidence at trial, that Smollett, while he was reporting a hate crime, he actually was trying to obstruct the police. He didn't want the police to actually find out who the culprits were, because he was afraid they would turn on him and testify. So he refused to produce his phone. You heard all the evidence. He refused to produce it because there's 50 contacts on there with Abel Ossadero that he didn't want them to find. So he just refused to cooperate. Number 2, he refused to let the police look at his Northwestern medical records the day that he reported the crime, because he knew that he wasn't seriously injured, and that would not support his argument about the attack. So he refused to cooperate. And then he wouldn't even do a 3-second DNA swab when he had reported this, and reported that the rope may have the DNA on it of these culprits. The police wanted to eliminate his DNA, and he wouldn't do it. So while he's reporting this, as far as you considering whether it's a serious crime or not, I respectfully suggest that the fact that he not only planned out to falsely report it, but then to obstruct the police investigation. And yes, the issue about whether it's serious, and I've heard a lot about, well, no one goes to jail. That's not true. Every case, Your Honor, if anyone knows better than you, each case is decided individually. But I did go out and do some research because I was curious about all this stuff I've been hearing that, well, no one goes to jail for this. That's just not true, by the way. There was, in fact, I think there's 6 cases in the last 5 years that we found in the research of people in Illinois going to jail for this very conduct of falsely reporting crimes to police. It is a serious course of criminal misconduct to do it. It's a felony, and I think there was one decided by appellate court 4 months ago, which involved reporting to the police that the person was hit by a police car when they weren't. I think what happened here was a lot worse than that, and that person got 14 months incarceration for filing a false police report. So so yes, I do believe that this conduct is serious, and I respectfully suggest it's an important factor to consider. Aggravating factor number 2 is lying under oath. I'm not going to go through it. Your Honor heard the testimony. He made a choice. By the way, I'm a defense lawyer, Your Honor. Yes, we all get choices to be made, and defendants can make choices. But he made the choice, Mr. Smollett made the choice, that he could deceive that jury and went on the stand and lied to them about so many different things. I'm not even going to, I was going to summarize some of them, but I don't even want to. I don't need to. You heard what happened during the course of the trial. Testimony that he went out and at 2 o'clock in the morning to buy eggs from Walgreens when the Walgreens was not even a 24-hour Walgreens. It was a ridiculous story. The fact that one of the attackers is white and he didn't even know who attacked him was ridiculous. The fact that the brothers had no foreknowledge and just happened to stumble over there into a Streeterville that they didn't live in and were happened to be there at 2 o'clock in the morning when he was out going through that in that stairwell. All of that were intentional lies. And by the way, people do not, that going in front of a jury and deciding to lie under oath to see if you can beat the case and obstruct justice is a serious course of criminal misconduct that I think should be taken into consideration. I also will tell Your Honor that the issue of lack of contrition here, I do think is an important issue, and Your Honor can decide how much to give to that. But the reason I went and did some research on this, Your Honor, because I wanted to make sure I was handling this issue properly before Your Honor. And so I went and did some research. And the Illinois Supreme Court has made a big deal out of the fact that sentencing judges absolutely can consider that someone has shown no contrition whatsoever, particularly after they have been convicted of a crime. Now, it may be, it could be here when I'm done talking, Mr. Smollett will speak to the court and explain how he's accepting full responsibility for his criminal misconduct. He may do that. That's fine. Let's see if that happens. But at least at this point, that has not happened. And there's an Illinois Supreme Court opinion called People versus Ward, in which, I'm going to quote, the Supreme Court told sentencing judges, a continued protestation of innocence and a lack of remorse may convey a strong message to the trial judge that the defendant is an unmitigated liar and at continued war with society. That's the quote from the Illinois Supreme Court. So I do think it's at least a factor for Your Honor to consider during the course of your decision-making here. So let's go through the different issues of sentencing and just talk about them briefly. Term of imprisonment, yes. We are recommending to Your Honor that the seriousness of this crime should result in a period of incarceration for all the reasons I've just articulated to you. As you know, that each of the counts, the felony counts, 3 years times 5, he faces 15 years maximum in jail. And Your Honor knows that Illinois law provides that you have the power to impose a term of imprisonment if you find that probation would deprecate the seriousness of the offender's conduct and would be inconsistent with the ends of justice. I'm not going to suggest any amount of time, because if there was ever a judge that had the ability to understand what to use discretion, whatever you decide is your, let me just say this, your ability to decide based on all your years of experience and your years on the bench, we accept that, and whatever you decide on that issue, you decide that, but we do believe that it is a serious criminal misconduct that warrants an appropriate amount of prison time. Number 2, restitution. The Illinois restitution statute covers class 4 felonies and says that you shall determine whether the defendant should be required to make restitution in cash for out-of-pocket expenses. You've heard the evidence. It's $130,000, $130,106, and on that issue, Your Honor, we believe that's the appropriate amount of restitution to order. Now, I will say that that first Smollett case, which led to a $10,000, it's called a forfeiture in the record, okay? It was some kind of forfeiture to the city of Chicago. It was not restitution. The city of Chicago did not claim, was not trying to get, that was done by the state's attorney's office with no agreement by the city of Chicago, but he did pay it, okay? So at least our thought is that that would be deducted, that the order for restitution would be $130,000. That's the right order, but he does get a credit for that because he did pay it under, let's call it confusing and this unusual circumstances that I've talked about in another report, and I'm not going to talk about here. Probation. As Your Honor knows, under Illinois law, for a Class 4 felony, you can impose a period of probation not to exceed 30 months, but you cannot impose both a term of imprisonment and a term of probation on the same Class 4 felony convictions under the case law. So that our recommendation to Your Honor is that you have the authority to impose imprisonment on one of the counts that he was convicted of, one of the 5 counts he was convicted of, and then on one of the other 4 or more than the other, you can impose a consecutive term of probation to follow. Now, why do I talk about that? Okay, why should that be? Because he's not a violent crime, etc. Your Honor, in 2007, Mr. Smollett had a prior conviction in 2007 in connection with a DUI arrest in California for providing false information to a police officer. Mr. Smollett reflects that this case today is not the first time he had lied to law enforcement officials, and so I believe as a result, the Office of Special Prosecutor believes that an appropriate term of probation, whatever you decide in Your Honor's discretion, should follow an imprisonment term. Next, criminal fines. Again, this is in Your Honor's discretion. You can decide the maximum is $25,000 for 5 counts. That would be $125,000 for each, for the totality. We recommend a reasonable criminal fine to be imposed by Your Honor based on your judgment about it. Community service. Let's talk about community service because there's been, the defense has asked that maybe you should consider community service, and we agree with that, but it should be a condition of probation following a term of time in jail and following a term of probation. But as part of the probation, you have the authority, as Your Honor knows, to perform, he can be ordered to perform 30 to 120 hours of community service as a condition of probation under Illinois law. We respectfully ask Your Honor to impose and to at least consider maybe it should be devoted to an appropriate black or gay community service organization that can benefit from Mr. Smollett's hours of community service. And so, Your Honor, I'm going to conclude. You know the case very well. I was appointed as special prosecutor, as Your Honor's already pointed out here today, because Judge Tooman, after looking at the unusual way that Smollett 1 was resolved by the state's attorney's office, when the case was dismissed completely, with absolutely no term of imprisonment, no criminal fine, no restitution, no probation, no supervision, nothing, that Judge Tooman found that to be what he described as to be a significant mistakes by the state's attorney's office, and he believed that the public's confidence in the criminal justice system should be restored. I will tell you, at least as a trial lawyer, I believe this trial in this case has already done that, I believe, okay? The public wanted Smollett to be put, not just have his case dismissed, but Mr. Smollett should be put on trial and let a jury hear the evidence and decide it. You brought that to happen at the end, well, almost still in the middle of a pandemic, you made that happen. And absolutely, Mr. Smollett got a fair trial here. There are some ins out there, though, that relate to punishment. And I respectfully suggest that the confidence in the criminal justice system can be restored as a fair and proper sentence is imposed in this case. I have nothing else to say unless Your Honor has questions of me.
Thank you. I have no questions. I'll hear arguments in mitigation. Mr. Uche.
Mr. Webb, Judge Lynn, may it please the court. Judge, the defense is respectfully asking that you, as a starting point, consider the following. The extraordinary media publicity surrounding this case, the intense negative backlash against my client, Mr. Smollett, the significant negative impact that has had on his career, his livelihood, his family, who's been in court all the time, and perhaps more importantly, his reputation. All those things taken together in of themselves are not just extraordinary, are not just unique, but indeed eternal enough punishment. And some will argue more than enough punishment for a low-level Class 4 felony in this state, and I dare say in any state in the Union. I begin by quoting a judge. I am trying to treat this case more like other cases, not differently than other cases, but more like other cases. That was you, August 26, 2021. You made that statement to us while we're discussing jury selection and procedures. And so I begin by asking you to treat this case like any other low-level Class 4 felony. Somehow this case has turned into a sheep in wolf's clothing, a misdemeanor dressed up as a felony, essentially. And how do I know this? Mr. Webb spent the entirety of his argument talking about the time wasted by the Chicago police force, time wasted by the city of Chicago. He also spent time talking about the impact this could have on the LGBTQ community. But there are problems with that, of course, Judge. Because I searched the disorderly conduct statute, the entire team did, and I was searching to see if there was any aggravation or enhancement ladder that our legislature in Springfield put in place for Class 4 disorderly conduct. Did they meet during the discussion of the bill that they passed to say anytime anyone wastes more than $30,000 of resources, it becomes a Class 2? Anytime anyone wastes more than $500,000 of resources, it becomes a Class 1 or maybe a Class X. No, it's not there. I searched for it. But what we do have is an enhancement ladder that does exist in the disorderly conduct statute, and it's right here. If you call falsely 911 or the police to claim that there's a bomb threat, any terrorism-related issue, you get a Class 3, and that's the only enhancement ladder. And I trust that our legislature has the common sense to think about time wasting and money, but it's already infused in the Class 4. That's the whole point of a Class 4 disorderly conduct. Mr. Smollett is not being accused of screaming fire, fire, or bomb, 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 which will cause a public safety concern. That's why the legislature put that in there. Because they were thinking of a situation where someone comes into a movie theater, screams bomb, and there's a stampede and people could possibly die. So there's a public safety concern infused in that enhancement ladder. They did not think about money or time wasted because it's already in the statute, it's already accommodated for in the Class 4 statute. And we know they think of these things when you look at the statute, the armed robbery statute. If you rob someone with a gun on top of the Class X enhancement, what happens? You get 20 years added to your sentence. You rob someone with a gun and you discharge that gun causing great bodily harm, what happens to you? 25 to life, enhancement on top of the Class X. Even down to your basic speeding laws. You're driving 26 miles per hour over, now Class B misdemeanor. You're going 35 miles per hour, it's now a Class A misdemeanor. The legislature thinks about this thing. Mr. Webb and OSP wants you to legislate law that doesn't exist in our statute, and that is not for the courts. The $130,000 they talk about, well, there are problems with it. We can't take it at face value. Judge, you have the victim impact statement in front of you. If you look at the first 2 pages, there are no dates on that. If you look at the second 2 pages, highlighted are entries with dates, and only 4 of those entries are before February 15, 2019. Why is that important? It's important because on February 15, 2019, the Oshundaya brothers, according to testimony, confessed allegedly to this incident. And that was the day detectives let them go and began the investigation on Mr. Smollett. So why do we now have charges, most of which are after 2/15? Judge, the second point I'll make is we're asking you to adopt the previous sanctions. Mr. Webb tries to dress it up like a forfeiture, call it what you want. Mr. Smollett was fined $10,000. Black Law's Dictionary, that's a fine. You can't punish a person twice. And I know you've denied the motion, that's fine, but that's not why I'm bringing it up. Because there's an 8th Amendment issue here, cruel and unusual punishment. Punishment that is too severe for the offense. And how do we know this is too severe? Assume, or the jury found him guilty, okay. But Smollett won. To 2019, they made him pay what? $10,000 fine, which has never been returned to him. The sovereign of the state of Illinois, through their agent, the Cook County State's Attorney's Office, said, Mr. Smollett, we're taking your $10,000 bond, we're giving it to the city of Chicago. Bye-bye, he's never seen it. That is a fine. Then they made him do community service, which he cannot undo unless we had a time machine. So those 2 things are punishments that has been meted out to him. Sanctionable steps. And now Mr. Webb has come here to ask you, on top of those 2 things which he cannot undo, nor can anyone. You can deduct it all you want from the fines or the restitution. It's still a fine that occurred. They're now asking you, on top of those 2 things, we want you to give him community service and jail time. He doesn't say how much jail time. And jail time. And by the way, while you're at it, for the restitution that has no dates on the first 2 pages and the other 2 pages, there are only 4 after 2/15, we want you to give him that too, $130,000. It's overkill. It's called beating a dead horse. And that is not justice. That's retribution. That's punitive. And that has no place in the judicial system. Why should Mr. Smollett get probation? You've heard from the witnesses. I'm not going to rehash the testimony. And you specifically heard during the trial from someone who was in here today, Pamela Sharp. She talked about how Jussie gave most of his payments, his earnings, his salaries to charity. How many people do that? I haven't done it. But maybe I've learned something from Mr. Smollett. How many people at the age of 16 were taking a bus to go do community service and charitable foundation work for other people in other countries that weren't even here? How many people do that? Most kids at 16 are playing video games. I did. And that's the type of person we want to crucify for a class 4 low-level misdemeanor type felony and slam him in jail. That's what we do to people like that. When according to the jury, they've made a mistake. Lock him up. There's no violent crime, no felony that is above a class 4 alleged. He has no felony conviction in his record. Mr. Webb brings up the DUI, but conveniently left out the fact that it was a misdemeanor. And he was drunk. When people are drunk, they say silly stuff. Let's not forget that. And he was 24 years old. He was a young man. If Your Honor doesn't seem to, if Your Honor is somehow, and I don't know what's in Your Honor's mind, thinking, Mr. Uche, well, that's just you, you're his defense attorney, of course you're going to ask for probation. Well, the adult probation department here in this building that has been around forever, gave you a probation report, Judge, and what did they rank Mr. Smollett using the Ohio risk scale assessment? They ranked him a 7. And when you compare that to the scoring system, 0 to 14 is considered low risk. So Mr. Smollett is not just low, but he's low within the low risk standard. 15 to 23, moderate risk. 24 to 33, high risk. 34 plus, very high. What do they recommend for a low risk individual? Minimal supervision, non-monitoring supervision. That's what they told you. Point 4, there's extraordinary public policy. Mr. Webb got up here and talked about Mr. Smollett's conduct, and that's offensive. He's a black man, he knows. You can't educate him on racism issues. And Mr. Webb got up here and said, well, Mr. Smollett, what he's done, because remember, they're trying to give you an enhancement that doesn't exist. What he has done, Judge Lynn, and this is what Mr. Webb is telling you, is he's now negatively impacted members of the gay community who would not want to report. Where are the statistics? Who said that? We still haven't got past the part that his case was dismissed and he paid a fine. And that's some serious constitutional issues. But what we do know, statistically, in an era of partisan tribalism and hyper-aggressive tribalism, political tribalism, there has been bipartisan agreement that there's disparate treatment of black men and minorities in the criminal justice system. This is no longer a controversial topic. President Trump, a Republican, pushed forward the First Step Act. President Obama was known for his criminal justice reform. Governor Bruce Rauner put reform forward to remove low-level, Class 4 nonviolent offenders from custody. And Your Honor, we have to look at stare decisis, precedents in this courtroom. Your Honor has had multiple Class 4s, and I listed them in what I turned over to you. Some including some level of violence, domestic violence case number 19 CR 0139401. With a prior, he got 2 years probation for Class 4, and I'm sure Your Honor has absolutely every reason to have given that. DUI, serious offense, involving public safety, 24 months probation, case number 21 CR 0059101. And I list a bunch of cases, 6 more, Class 4 felonies. And I bring this up to say, Your Honor has absolutely always been on the right track. And I do not mean to be condescending, I hope I don't come off as that. But this is an important issue. You heard from Tamara when she read the NAACP letter, the Black Lives Matter letter, and the Innocence Project letter. And they all say that there's disparate treatment of black men in the criminal justice system. They get punished harder and harsher for low-level offenses compared to white counterparts. That's a fact. Mr. Webb was appointed special prosecutor almost a decade ago in a case involving involuntary manslaughter. That's why I was surprised he was asking for jail time, because that individual, what did they get? 30 months probation, including 60 days in their house, home confinement, for an involuntary manslaughter where someone died. And I showed the statistics, Judge, I put it in the filing that I made. The irony of this entire thing, when Mr. Webb gets up to point out that Mr. Smollett disrespected somehow the black community or the gay community, the irony of this situation, and Mr. Webb quotes statistics that he believes show that people are punished and false reporting. Well, most black men and most black people are falsely accused all the time. And in an age of social media, we're inundated with reports about this. And what happens to those things? They go unprosecuted, underprosecuted, and not prosecuted at all. So why are we jumping up and down and acting like this is a murder case? It's not. Even one of Mr. Smollett's jurors gets the big picture. This unknown juror spoke to the Chicago Sun-Times a day after the verdict. What did they say in quotes? "We didn't know what the penalty will be. Are we sending this guy to jail?" she said. The juror said she hopes Smollett gets probation. They were the ones that sat down through the evidence, and even her gets the picture, or he, whoever this juror is. They get it. What does jail accomplish? Mr. Webb is asking for incarceration for a low-level class 4 felony. Well, Your Honor saw the submission from a medical affidavit. The jails are inundated with the pandemic. Illinois had one of the worst cases in the world. Sending Mr. Smollett to jail is almost like a death sentence. Yes, it is. Because anything medically can go wrong. And everyone reacts to the COVID-19 infection differently. Now, he hasn't gotten it yet, thank God, but I don't know what will happen in the jail, where I showed you studies show, unfortunately, the guards in the jail, unfortunately for them, and it's wrong, are always the last to get medical treatment, including booster shots, which as of January, they haven't even received. So we send Mr. Smollett to jail, he dies of COVID, and what, for a class 4 low-level offense? Mr. Smollett is a high-profile individual. There has been negative backlash against Mr. Smollett. I'm not complaining. We're the defense team. It comes to the territory. Each and every one of the defense lawyers has received racist or sexist attacks after this case and during this case. And that's okay, we take it. We're defense attorneys, that's what we do. So now imagine the attacks that Mr. Smollett has to live with for the rest of his life. That is punishment enough, mentally. The last point I'll make is public policy. There's public policy against retribution. Politics has no place in a courtroom. The courtroom is a graveyard for politics. And they can get up here and say the pride of Chicago was offended. That's fine. And time and money was wasted. And I heard Mr. Webb state to this court something I couldn't really decipher during the trial, that Mr. Webb did it for himself. The problem with that is we've all heard testimony from multiple people who say that Mr. Smollett does things for the community. And moreover, let's not forget, everyone testified unimpeached on their side, or on our side too, in terms of this particular issue. Mr. Webb, in terms of deciding or trying to figure out what drove Mr. Smollett to do this, started off by saying he wanted more money, then it became attention, then it became because of the letter he received. They haven't even up until now stuck to one issue. So I push back on that theory that Mr. Webb states to this court that Mr. Smollett did this because he was somehow benefiting himself. There was never a clear picture coming out of that, for that. Judge, we ask you, at the end of the day, you are the one who decides the sentence of Mr. Smollett. But we ask you to decide it based on the law, not on the time wasted, not on a sprawling investigation. It's not here in our law. It's not accounted for. And there are many things you can do to make this a teaching moment. Here's someone that is a star. He's well known, people like him. After this case, or during this case, I doubt that anymore. But at the time, he has suffered. And we see it every day as a defense team. He has suffered, and it's enough. It's really enough. And I'm not asking you, Your Honor, I'm not in front of you, and I've appeared in front of you on other cases. I'm not here telling you, Judge Lynn, give him a break, let him just walk out and forget about this. I haven't asked for that. I haven't told you to dismiss this case right now in this argument. But I do implore you and I ask you respectfully to focus on the law and to tamper justice with mercy. We've all made mistakes, Judge, in this life, and I'm speaking from your point of view because there was a conviction in this case. But what I'll leave you with, he that is without sin among you, let him cast the first stone. Everyone, a lot of people jumping around on social media, crucify him, how dare him. Everyone's made mistakes. And so, Judge, I'll be asking you to follow your precedents and follow, some of the recommendations. A lot of organizations offering to supervise Mr. Smollett. And that's really the way it should be. People are watching this case. Minorities, black people. I've gotten so many letters. A letter Mr. Allen and I got yesterday from a lady complaining, how is a police officer who shoots a young man 16 times getting out of jail for 3 years and someone might be suggesting incarceration for Mr. Smollett? That's a letter we got. So people are watching because people think in the black community that there is a double standard, and there is. But Your Honor has been one of the few people in the United States in terms of dispensing justice that has stuck to the letter of the law and has treated class 4 felonies the way they ought to be treated. And so, Judge, with that, I submit my client to your hands, and I ask you for mercy at this time, and I ask you not to allow a political stoking to influence your decision, which I know you will never, and I ask you to focus on the law and the fact that there is no enhancement ladder for time wasting and resource wasted. And so, Judge, one more thing I would say, Mr. Webb talked about the restitution. Now, Your Honor has the power to give restitution, and we concede that point at this time. But, Judge, what I would remind you is if Mr. Smollett has to pay that amount or any amount Your Honor deems fit, he's lost nearly everything. He's had a very negative, significant impact on his career and his finances. So I would just ask that if Your Honor is going to give him that restitution order, you give him some time to pay. And I was shocked Mr. Webb was asking for incarceration because for a second I wrote out my notes thinking he was going to ask for some sort of suspended jail time, which will in a way be a middle ground. I disagree with it. To say, Judge, maybe you give him a suspended jail time to allow him to pay. If he doesn't pay the fine within 6 months, he gets 6 months in jail. I thought that's what Mr. Webb was going to say, but of course I'm not the prosecution. So Judge, I would ask you respectfully to give Mr. Smollett probation, and in fact, I will be asking for no fines based on the fact that he's been fined before. Thank you, Judge Lee. Thank you for listening to me.
Mr. Smollett, you're about to be sentenced in this criminal case. Is there anything at all you'd like to say to anyone? Want a break? We'll take a break. 5-minute recess.